All right, guys, welcome, and I'm sure others will start funneling in here. We're going to get going here in about 2 minutes. I did start the recording. All right. Can everybody see my screen okay and hear me okay?
You good?
Yep.
Perfect. All right. So this is a seminar on foreclosure, protection, foreclosure defense, and retaining equitable control of property. Um, this is another in a series of free seminars that we're doing. I'm trying to put one out each month. Things have been extremely busy. Um, but this is going to be hopefully a monthly occurrence here with these seminars. All right, if you would just mute out. There'll be questions at the end. I'll open it up for questions at the end, and we'll get started here. Excuse me. All right. So
Recording.
it is recording. It is recording. And if you guys could just keep it muted because I get a big echo in the back when the mics are off. All right. So anybody that's been through a foreclosure knows this isn't just a financial event. It's extremely stressful. There's a lot of emotion. There's a lot of fear, anxiety, and most of the time it's because most folks don't even have a clue what it all entails for starters. But it isn't just a financial event, okay? And from a trust standpoint, it is jurisdiction and fiduciary failure, a failure on behalf. Excuse me, sinuses have been bothering me all day. Okay, so a trustee, and where we are looking at this is from a trust perspective. Um, the principles and the concepts are the same. The defenses and things are the same, except that you're not directly involved, and there's a difference in the way things are defended out of a trust structure as opposed to um, getting out there as a man or a woman and fighting your battle. So, but it's a jurisdictional failure up front, and usually a fiduciary failure, right? Something broke, something happened that caused a foreclosure situation. So what we're going to go over tonight, and what you'll learn in the training if you do decide to take the mastery course, okay, is how to you'll understand foreclosure, um, equity versus law, right? And there is two sides to the foreclosure. There's the legal side, right? And then you've got equity. Done right, you can protect your equity from the beginning and not chase after it at the end. Structuring is very big, but you'll understand foreclosure both from equity and the law side. Identify where rights are lost on both sides. Learn the positions of power and how to set yourself um, up for success to deal with a foreclosure if you need to. But hopefully, uh, to shield from that happening. Okay. And you'll learn how trust structures do change how a foreclosure is handled. Okay. Disclaimer, I'm not giving legal advice. I'm not even going to go through this. You can read it, but this is not legal advice. This is education. Okay. This is learning what to do. Okay. Um, every situation's a little different. This is why it's not legal advice. Every situation's a little bit different. Um, and strategy definitely depends on the facts and how you execute your strategy specifically. Okay. And full implementation is taught in the master class. Okay. The problem, most people don't understand what they signed. This happens all the time when there is a benefit involved. I want the car. So whatever the contract, I don't care. I didn't even read it. I just want the keys. Okay. Same thing goes with houses and most large purchases. Um, Folks buy them and they think, okay, this is it. As long as I can keep the bills paid, I got a roof over my head. Uh, they don't understand what they signed, what the responsibilities of both parties are, or all parties. It's not maybe just two. Okay. Um, don't control title versus use. Okay. Uh, they use it. Okay. They live under it, but they don't control the title. And this is where a trust comes in. Okay. They don't act until it's too late, right? They've missed payments. They were afraid of the notices and didn't know what to do and don't trust lawyers or the system or whatever. But that fear keeps them from doing something about it. Okay. Until the next thing you know, you're being served and it becomes a court action. It doesn't always have to become a court action. And that's one thing about living in the private and doing things privately. Okay. Because the whole idea is to keep things out of the courts. Okay. So, and then most people will operate entirely in a defensive mode, you know, um, they're fraud, they're this, they're that, and again, between that and the fear and the misunderstanding or lack of understanding of the process and how it got that way, and even their own mortgage contracts and all the closing documents they signed. Okay, uh, usually it would take reading those things, understanding those contracts, every line of it. They can pack a lot into a small contract that doesn't benefit you in the long run or your estate. But you wouldn't know if you don't read it. All right. So the way the system, the Kingdom of Heaven Trust Management System view, that's KOHTMS, and operating through a trust structure. Okay. Foreclosure is literally it's a process of enforcement of rights, right? So, and those rights are on both sides. So that enforcement can go both ways. In a foreclosure can be equitable from the equitable title and those rights. It can be legal and the rights that are being enforced on that side. Okay. Based on presumed agreements, there's a signed document, a signed contract, or series of contracts, right? And it's against a legal person or a legal position, not you personally. And that's another reason why people freeze in their tracks and that's not just with foreclosure. It's with a lot of things that have to do with courts and law and dealing in unfortunately, this is a lawsuit-driven adversarial world we live in, and it's literally propped up on all the lawsuits and all the courts and all the land. Okay, and when I say it's against a legal position, okay, That legal position could be a title holder, right? And usually it is either the legal title or the equitable title. Okay. If you're not the title holder and your trust is, that's a much more strategic and leverageable position. Okay. Definitely has more uh, leverage to negotiate and administrate. Anyway, moving on. So, who actually owns the property? And some people say, well, I own my property outright. I have no debt on my property. It's a wonderful feeling. There's still a debt that reoccurs every year in most instances, right? Taxes on the place is one. But foreclosure dealing with the bank, okay, do you own it? Does the bank own it? Does the state own it? Or does the trust own it? I'm going to open it up for those questions if anybody wants to answer this. Nobody? I currently can't see all the folks that are on here right now, but all right. So who does own the property? Okay. And there's interests. Okay. Ownership is an interest. Okay. Who has an interest? You have an interest, right? You have a roof over your head. So you have a beneficial interest, a true beneficial interest, where that may be your home, it may be a rental property that you own, and the trust gets right. The trust gets revenue. If it's owned by the trust, you're the beneficiary, right? The bank, if there's a loan against the property, a lien against the property, outstanding debt, the bank has a legal interest, right? And the state, how's the state fit in? Most often than not, one is obvious, taxes, right? We talked about it. And the other is jurisdictional control of the venue. Who's going to hear this? And then now look at that, and those same four parties, uh, which ones are in bed together? Are you in bed with the bank? No. Well, you are in a way, not a comfortable relationship. You're in bed with the trust. Hopefully, you're sleeping soundly, right? But the bank and the state. If anybody's gone through a foreclosure, especially if it's a non-judicial foreclosure, they push it through like you're an eviction court, and you're just a tenant in that property that you hold an equitable interest in, because they're trying to get possession. So who actually does own the property? It's a mix. It's ownership has interests, and in this case, with the bank, there's mixed interests, and by default, you and your trust, or your trust, are uncomfortable bedfellows with the bank and the state in that picture in the foreclosure court. All right. Title versus equity. Legal title, right? Who holds record authority, right? Who has the authority who has subject matter jurisdiction, right? Equitable title decides who benefits, right? And control is determined by who stands in equity. That's how it becomes fair, guys. And if it's moved in from trust, it can start in equity, because trust is born in equity. It starts in equity. Anything to do with a trust has to be an equitable matter. We teach these things in other courses, depending your trust estate, things like that. There's other courses where we discuss equity in more detail. But equity is something that you do daily. It's not just some legal technique. It's a way of operating and administrating your own affairs. Okay, but control is determined by who stands in equity. In other words, who's got clean hands, who's doing the right thing because it's the right thing to do. Um, and more often than not, if you're going to win a case in foreclosure, um, you know, a lot of the times you're going to find that you can actually prove where the bank or the state acted in bad faith or with, you know, without clean hands. So, what is the critical lever? Most people hold no structured equity position. They just pay that mortgage every month and think they own it because they paid the mortgage. They have no lien on that equity, most likely. They don't have um, a position, okay, a secured position, whether you're in first party position, right, or if the loan's in second position, right? There's a hierarchy in how things get paid out when things are sold, okay. So most folks don't have any structured equity position. Okay, they haven't set it up. They haven't protected it. They haven't perfected it. Their claim. Okay, they operate as beneficiaries without any control whatsoever. Okay, and they can't enforce their equitable rights because they have never learned to set those up. Most folks don't have a clue how to protect the equity in their home. Um, I've been doing financial planning for a very long time. I was a certified financial planner in New York in the 90s. Um, anyway, when someone buys a home and they don't make a claim on their equity and lien it, okay, um, you can't enforce rights that you haven't exercised. Okay. So when I say equity in a home, right, you've got the market value minus the debt, and the remainder is equity in that home, right? That's one form of equity, and one that most folks are at least semi-familiar with. So when you've got equity in a home, let's say a house is worth $1 million, the bank is owed $400,000, and the equity position is $600,000, right? And you miss 6 months worth of payments because you lost your job or one of the family lost their job or whatever emergency caused it to go into default for 6 months without negotiation, without talking, without communication, with threatening letters and whatever. Okay, and they find themselves in a foreclosure situation, and the bank forecloses, and you're tossed out, and your 600K, where did it go? Move on. You can think about it. So, foreclosure basics. Okay, foreclosure is a remedy. Most people would be like, no way it isn't. It is for the bank or the lender, right? Or their trustee in some cases, right? Or any of the supposed service companies that are servicing the loans. And you don't know who has it, who's holding it, holder in due course, things like that. Okay. But it is a remedy for an alleged default based on a security instrument, right? Somewhere in your closing docs that, you'd find the answer to, you know, uh, what caused the default, okay, within those documents, within that security agreement, the promissory note, the security agreement being the mortgage or deed of trust, okay. Anyway, moving forward. So, what is being foreclosed? It's not the house. The house is not being foreclosed on. Okay. That is the interest tied to the note, the security interest, right? And it's also a position held in the contract. Somebody's going after their rights. Somebody is enforcing their rights for a supposed breach. The simple answer to what a foreclosure or what is being foreclosed upon. People foreclose not on a house, but on their interest the in the house, all right, in the property, their secured interest. Why they can have a tax sale or foreclosure because of taxes, things like that. Okay, so obviously, but again, this is an overview. So the mortgage or deed of trust secures the note, ties that obligation to property, all right, and creates enforceable interests. Okay, all spelled out in the contract that you agreed to. So a lot of the problems, I get, actually, I lost my job or was hurt or something bad happened that caused an emergency and there was no backup plan and it just happened the way that it happened. But even if that were so, um, there are things that you can do from the beginning, before and should be planning to do before you even, buy the property. There's quite a few things you can do to protect your interest in that property, your equity in that property. Okay. Lots of things you can do. Okay. And also knowing the terms and what you're getting into, you can go over with a fine tooth comb. Just because they wrote a contract doesn't mean that everything has to be taken as delivered or nothing. And most people think that's the case. So if I rock the boat, I'm not going to be, swimming in that pool in the backyard. So they'll agree to whatever. It doesn't matter because the benefit outweighs whatever is in that piece of paper is what the thought is. And a trustee doesn't act, that way. It's not shoot from the hip. Okay. So the note versus the mortgage. Okay. There's an issue, right? These are little things that you can utilize in defense. Separation issue. If the note versus the mortgage, okay, if they're separated improperly, challenges arrest. Okay, you can challenge an improper mortgage. If a mortgage doesn't have the note attached to it, is not a valid claim. Okay, what is a default? Right, these are simple terms, contract terms. A condition that triggers, okay, triggers. Not always a true breach. And again, a true breach is, intentional breach, right? Maybe. But even if it's triggered, it doesn't mean that it can't be remedied prior to long drawn out court battle and potential loss of the actual asset. Okay. Usually, when I say it's administratively constructed, I mean that if you're doing your administration properly and you're getting into a contract in the first place, okay, you are, this is what you're doing is you're structuring the agreement, right, which is part of the administration of a contract, is being a party to creating the agreement. Okay. And it's always administratively constructed. Okay. The contract, the defaults, the remedies should be in the contract. If you were the creditor, if you were the one doing the lending and they defaulted, right? You'd want the remedies within the contract and you'd want them. I mean, in my case, I would say I want an equitable contract, not one that is, you know, misaligned, one that it may be unconscionable or very lopsided, right? I want to look ahead of time, okay? What the terms of purchase are, or in this case, it's, you know, uh, they say about cash is king, but if you are borrowing, these are things you want to know. Default. What's a default, right? Can the bank default? Sure, the lender can definitely default. Okay. So how does a foreclosure come about? Usually starts with some missed payments or breach of contract terms. Okay, whatever, whether it's missed payments or other. Notice of the default is sent, an administrative process. The bank will send you or the lender will send you a default notice, right? Usually from that point, that default notice most likely will have opportunity to cure, and maybe even instructions on how to cure the default, right? If it's ignored, then you get acceleration, which means it doesn't mean it moves faster, although it does. Acceleration means that they're going to accelerate from, okay, you got to come up with 3 months of your mortgage payments, taxes, and insurance, or we're going to foreclose. Okay. When they go to that next level of acceleration, it's not just, you know, you got to come up with the 3 months mortgage and fees for late fees. Now you've got to come up with the entire amount, or we're going to come and bring you to court. Okay. So it's not automatically, um, once they go to court, acceleration, they have a right to accelerate in most of those contracts. There's a lot of things that could accelerate it, including if you are in doing trusts, the way that you set up a trust, if there's a loan in, let's say, your name personally, right? And you move the property into, or the equity in the property into a trust. If you're the only thing you can move into trust is what you own, and you own the equity. Okay. So if you were to set up a trust and you don't do it properly, right? There are federal laws in the U.S. I'm sure there's something similar in other places, but you can move your equity and your property into a trust as long as remain a beneficiary of at least 10. I believe so. I believe it's either 5 or 10% beneficiary, and it won't cause acceleration of a mortgage loan. And again, acceleration means the note will be called then. So if it's 400 grand, you've got whatever amount of time the court will decide to pay it off. Okay. But they'll accelerate before filing. Okay. They'll go to judgment, whether it's non-judicial and it's just they're going to file their administrative process and boom, the court's going to give it to them because they followed the procedures of the non-judicial foreclosure. Most people are going to freak out in those non-judicial states and don't realize that they have to sue in order to get their rights recognized and move it into a courtroom instead of, the lender playing patty cake with the clerk. Okay. It's not judicial. It's administrative in a non-judicial state, but does not mean you don't have to bring a suit, or your trust doesn't have to bring suit to protect from the foreclosure. Okay. And if they side on behalf of the lender, okay, and the court forces a sale, the money's going to the lender. And I've seen equity swallowed up time after time after time after time after time by people who go into foreclosure and basically walk away from every dime they've ever put into it. It's a bank, guys, and that bank is your bank. That equity is your equity if you protect it properly up front, so it doesn't look like you're trying to move property offshore in a way, or out of the reach of, right? They may reverse that, or a court may decide that, you were being fraudulent or had fraudulent intentions. But if you do it up front, you can save yourself a lot of headaches. And if you find yourself in foreclosure, you can utilize that equity to either clear up the debt or any number of things. Anyway, moving along. All right. Where do people lose? Foreclosures. They lose because they ignore notices, right? They admit liability all the time. I meant to pay, but I couldn't pay, and these are my circumstances. They don't want to hear the stories. They don't listen to the stories. Anybody who's gone through this and maybe went that way, and tried to reason with them, they're not reasonable, folks. Lenders are not reasonable, not at all. Okay, but we admit liability by arguing, uh, you know, making promises, doing phone calls, not doing things in order, saying too much or too little, not knowing what to say in the first place, right? Failing to respond properly. And you have no structured record of every transaction that, or you may or may not have structured records of everything, including all of the original closing documents in a safe place that all the terms and conditions and all the remedies that you have on your side and what they have. Okay, and how to what you call it, maneuver between them. Okay. Again, a power shift here and when I say a power shift, it shifts when you move from it's you as the defendant to you, a trustee over the estate property that you have subject matter jurisdiction over and an ownership interest in, legal title to the equity, which most likely, if you've done it right, has a lien against it, the equity. And it's not a fixed amount because the market changes. It goes up, it goes down. So it's not a fixed amount. So the trust, a properly structured trust holds title, defines roles like beneficiary who gets the benefits of the property. You establish authority up front because again you're gaining legal title. Okay. Legal title is the administrative authority, subject matter jurisdiction. Okay. And you're creating standing, purposefully creating standing, whether it's for the equity that grows within the property. Okay. But standing intentionally to protect whatever rights are stated in those contracts that you negotiated. And most folks think that they negotiate the price from the seller, and that's where you're negotiating. It's not the only place you negotiate. All right. As I said earlier, trusts operate in equity. Foreclosure actions most always are pursued in law. Okay, always, and most often I would say 99.9% of the foreclosure actions are the lender foreclosing and exercising their rights against the homeowner, the individual. All right. So why does it matter? Equity can override statutory, which is harsh legal outcomes. Okay. Equity deals in fairness in um, creating a situation where unjust enrichment or windfalls don't happen or shouldn't happen. Okay. And again, it requires clean hands and proper structure. As long as you keep your hands clean or your state keeps its hands clean, it can easily move a foreclosure issue into equity. Okay. Where the lender is literally coming in statutory rule, right? But you have to have clean hands and you have to have proper structure and good administration. All right. Here's your positions. Okay. The debtor, right? Debtor is slave to the lender. A defendant, they change you from a weak debtor into a defendant. And it's not you that's the debtor, it's the legal entity that you either wear on your shoulder and act for, or that your trust operates. Okay. And a defendant, what are you doing? You're reacting, you're defending. Okay. It's not a fun position to have to defend yourself. Okay. Trustee, full control, administrative authority, subject matter authority over the res. The res in this case would be the equity in the home if you set it up properly and you have a claim against it. Okay. But it's the equity in the home that you control. And that's a very, and possession. Okay. But you control the equity within your trust purview. And if you have it protected properly, it becomes a thorn in the bank side or the lender side because they have to make sure that your claim, just as much as their claim, okay, is protected. They have a fiduciary duty to do so, or they don't go in with clean hands. Anyway, moving on. So a trustee acts for the trust, right, for the benefit of the beneficiaries, not for themselves. They control assets, they enforce rights, they demand accountings. And this is not something that's out of the ordinary in the courts or in administrative circles in the public, especially in banks. Okay. They have an authority that's protected in equity in those courts. Okay. You have a duty as a trustee, and they can't violate your duty. The courts can't violate your duty or force you to violate your duty, I should say. All right, accountings. What is an accounting? Well, without one, you have no idea, right? No clarity on the obligation itself. There's been no validation of a legitimate claim, okay, and no proof of standing. And this is just a simple task when you're operating in trust, because an accounting is always part of your administrative process. Excuse me. Okay. But without an accounting, yours or theirs, there's no clarity of an obligation. In this case, the one making the claim has to have clarity of the obligation. Here's the accounting, here's the books, here's the debt note, here's the security documents. Everything's together. They can't validate the claim. They can't validate the claim. They have no proof and therefore no standing. Has the lender ever provided a full accounting? Have you ever asked if you were being foreclosed upon? Okay. In the course, we get into a lot of the stuff. Okay. Securitization issues. Okay. Loans, 9 times out of 10, that loan's sold before the ink dries on the paper. They're usually bundled as mortgage-backed securities, and they're always bounced around from service company to service company, a lot of which are owned by the same stockholders. Okay, so they bounce around. If you call, you start doing well or strong, they'll drop their suit, and then you feel right when you're about to feel comfortable, they'll come back again. Okay, but when these things happen, okay, when you're analyzing your situation, your case, your foreclosure action that you're dealing with, or um, this is something you need to look at. Okay, was the loan securitized, sold, bundled, or transferred? Okay, and if so, how could they be foreclosing if they sold those rights someone else? So, where does standing come from? A right to enforce a valid chain of title and a proper interest. Okay, a valid interest. I lent you $500,000 for a home that was worth 700,000. You've been paying it for years. Now the house is also worth, a million, and you still owe me 280,000. Okay, without windfall, right? If it's there, they're going to take it at the sale. Okay, because they'll do a quiet title, they'll resell the house, they'll hold the finance again, it'll be bank owned property. They do these things all the time, guys, all the time. Um, anyway, they have they have to have and prove, okay, with evidence, a right to enforce a claim, valid chain of any note that was sold and where it went and who has it, and that chain is what I'm talking about. And the proper party has to be able to prove that they have the proper interest or they have no standing. Also will kill a case. So where's the biggest gap? Most common anyway. Missing or broken assignments. They assigned it to another servicer. Endorsements, if it was sold, maybe your endorsements in the contract that you had rights and things that you could have done. Okay. And documentation continuity. Most people don't even, stick the payment ledger in to the same folder, in the same location for their home. Same way people, that get their oil changed and keep every penny spent on a vehicle maintaining it, often get more when they go to sell it or upgrade it. Okay, it's the same thing here. I mean, if you've got good documentation, you've got good evidence. So even when errors exist, most people still lose because they don't have a clue how to assert the rights properly. And usually, by the time they're in foreclosure, uh, trying to track down some sort of remedy at the last minute, it doesn't work. It doesn't work. There's so many of them out there. Okay. It, it's going to be much harder, I should say. Not that it doesn't work. You can still protect your equity. It's harder because you don't have any documentation. It would be harder to work out a deal at that point where they've already gone through the legal expense and they see a massive win afterwards, right? You owe 300, your property's worth seven, or 700,000 more than that. You're the one with the majority interest in that property, or at least your trust should be. Okay, and people walk away from those types of situations all the time because they think that the bank's entitled to the windfall and that they're going to lose everything that they've been, that their energy created, everything that they put in repairs, upgrades, renovations, additions, all kinds of things, sweat equity, all kinds of equity. Okay. But people walk away from their equity, don't even realize that it's protectable or defendable because this is not something they teach you in the 18 years or whatever they keep you in school. They don't want you to know this stuff, but they will happily lend you all kinds of money to go to their school. No doubt about it. Okay. Notice processes, proper notice, proper record, proper timing. This is, we teach this in administration. Okay. It's the very same process. It's an administrative process. What are you administrating? Rights. Where are those rights enumerated or written out in the contracts that you signed? Because that's what you're working with. That is what you're working with. Okay. But because this is done daily and they're just so used to walking in and getting a judge's order or a clerk order for property, okay, that why bother telling anybody, about, how they can retain what they've put in, right? Or negotiate, a hiatus on payments for a while. There's a lot of different solutions that you can utilize if you're operating properly, keeping the proper documents, administrating it properly, negotiating instead of being afraid. There's a lot of things, and again, in these courses, I do try to touch on, mental things, what to say, how to say it, what not to say, because that has a lot more to do with it than just the paperwork. We're snared by the words of our mouth, and some of us can, can talk and retain stuff even under pressure, and others can't. Others of us can't. Our knees start knocking, everything's shaking. You don't know what the outcome's going to be, or even what the process is. It's like, final exam time, and you haven't studied all semester, and that's fearful. So if it's not if it's not documented, it didn't happen, and that goes both ways. Remember, this is not just you; this is them. If it is not documented, it did not happen. I have seen financial institutions over the years. I was in finance for many years. I see foreclosures happen, and there was no fight, none, and they've gotten windfalls in equity in those sales. Nobody ever stepped up with the claim. And if nobody ever claims it, and the bank, if the court wanted to micromanage, and many times uh, they may say, "Oh, no, 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 you're only entitled to this with your interest and your fees and your this. The balance is going to stay in the general fund, and we'll put a little notice on a computer page somewhere that says that so and so is entitled to." Money held by in the general fund. And sometimes that equity, or a lot of it, will end up back in the state coffers after, I don't know, 3 years, 5 years, depending on the jurisdiction. That windfall goes back to the state. There's a redemption period and a time that they have to notice and leave it open. And like I said, they're out there. There's websites out there that you can search to see if there's money owed to you. But again, you need to have good clarity from get-go before you get in the contract, looking at the contract. Consistency, meaning your bookkeeping, your record keeping. Have a straightforward uh, authority that you can prove, okay, and acting with clean hands, right, in good faith. And that's on your end, okay? And then you have use of equity, okay? You can restructure those obligations. These are just a few ways that it can be done. Delayed enforcement, right? Opportunity to sell. An emergency happened. We can't afford to stay here. But rather than losing my 15 years worth of payments, give me 6 months to sell the house and let the note carry the same interest and we'll delay this foreclosure and I'll sell the house and pay the note in 6 months or sooner, right? Delayed enforcement, right? It requires fairness. That's where equity can help, okay, to prevent unjust outcomes and those windfall equitable opportunities. And the equity is not fair, okay? It's siphoned off through windfall, unjust enrichment. They didn't earn that, and they know it. They're the ones that, may have gotten quite a bit of the payments that created that equity. Most likely were. Market plays quite a bit, though. Anyway, home equity is a tool. So what can equity in property do? It can be leveraged, right? It can be borrowed against. It can be used as negotiating leverage, and it can and should be protected. Okay. This is where learning about trust structures, properly structuring, in a proper asset holding trust or something similar, depending on what the property is. If it's your home you live in, if it's a business, if it is, an antique held in a certain way. Again, it's intentionally used, okay? Not just sitting there, to be used however by the bank or the next owner. It is something that you have access to if you understand what it is. And again, if you've got equity in a home and you find yourself in foreclosure, your pockets aren't empty. You may not have been able to make the payments, but that equity in your home, if properly protected and documented, can be used to negotiate solutions to a foreclosure. So banks and other types of note buyers, right? They buy performing assets, predictable outcomes. That's why they do credit reporting and, ask for references and do all these other things because they're trying to mitigate risk. Okay. And litigation uncertainty is a risk. A foreclosure can go on for years and years and years and cost all parties involved a lot of time, which equals a lot of money. And all that can be put to bed and also be used as leverage. Okay. They'd rather negotiate because that's an agreement to continue. You could walk away. They couldn't do anything. You could walk away from the property. They'll take your equity and they're happy to do so. And you could move on and they probably won't chase you very hard if they find that the home that you had and had all this equity in that they sold to their cousin's brother's sister at a massive discount of what the bank was owed. And they got all that equity. You never know what goes on in the back end of these things. I've seen foreclosure sales on the courthouse steps or that were supposed to be on one side of the building, but were held purposefully on the other side of the building. But their advertising said, go here. And the judge's minions bought it out on the other side for very, very little. There's a lot of corruption in the system, including the banks. Okay. But knowing that, you can, mitigate, your interaction. Okay. But also knowing what you have to leverage in negotiations by understanding what's going on, right? What brought you to that point? You have solid documentation. Show, you can prove your lien. They're perfected. You have evidence of trust, okay, and your documentation most likely is better than theirs if you're doing it, according to our programs here, Bulletproof Solutions system, okay, you can control the narrative, right? Narrative is a documented story. Who has better documentation? Heck, they are winning cases without ever even showing a ledger accounting. Nothing. And you want the whole accounting. You know, was there an insurance payout when, for breach, right? Missed payment or 2 or 3, 90 days. Was there a derivative paid out, insurance paid out on that breach? Because you could be sure that they insure their own breaches with their own insurance companies. Again, this is all contracts, it's all paper. Understand the system, and you can become, again, you get the position of strength, standing, tools, and ways to use them. Okay. So the strategic shift, and again, because it's personal, okay, can I save my home? And that's the emotional part of it, and that's the fear, and it all starts from that. Okay. Where is the control? And what's the correct position of control for you? Where do you stand? Where are you standing? Or do you have standing? And if you do you know how to express it and show it and document the evidence of it? So when you're a trustee and you're administrating your estate, it's not emotional, or the estate assets or trusts that are entrusted to you. Okay. Early action, maximum options, right? Hey, I'm sorry we were late this month. Please don't put it on the report, whatever. Simple. To, hey, we just had a family emergency. Um, we need to put the loan on hold for a few months. You can tack the interest on at the end, and it's a forbearance. Okay. And there's ways to negotiate that. But the more you wait, the longer you wait to start acting, when you're notified, okay, limits your leverage, limits those opportunities, and you'll end up fighting in court. You may lose the first time. You may win and lose over the next 5, 6, 10 years. I've seen them come back every 3, before the statute of limitations runs out for the debt. They have to bring it back, and they usually will and do. And it's usually a different service company, and it's usually different trustees and different lawyers. And if you dig far enough, you'll find a lot of those are, just another name with the same faces that own it and run it and administrate it, because they know the more parts of that system that they can control, the easier it is to foreclose and get these windfalls. So, what is the pre-foreclosure window? Okay. Pre-foreclosure window, okay, is where your leverage is the strongest before you get to court, way before you get to court. You can work out an arrangement. You can negotiate. Okay. And if you are, the way this course works, it is, again, the principles will apply left or right, whether you are operating in personam, right, as you, or in persona, I should say, on behalf of your legal person, or your trust is. Okay. Good foreclosure lawyers don't win, and most of the time they don't win Very rarely. Okay. And most of the time, it's because the lawyer comes in last minute, isn't really interested, just wants his check or her check. And, it's not as important to them. But the $650 or $1,000 an hour that you're going to pay them to fight on your behalf, just because they fight doesn't mean they win. And a lot of the reason is because your position and the way it was structured in the first place. So I know it's a hard pill to swallow, but we do have to, as good trustees, we have to take responsibility for our actions and how we got to that point in the first place. And if we're smart, we'll mitigate that in any future situation. If you're not facing a foreclosure, you're considering buying a property or dealing in real estate, um, you know, knowing what foreclosure is all about, the parties involved, the fractional reserve banking and how that all ties in, really getting a solid, thorough understanding of what's going on. It's not just this action in a court. Okay, there's a lot of things that go into mortgages and these death notes or debt notes that keep people enslaved. People, your energy, just that alone is worth putting into a trust structure because it's not you anymore. It's a management company that you work for or a management organization that you work for, and you're just doing your job. You're administrating. That's not personal. It's not. Um, it may be with its emotions, but not the same ones, and definitely a whole lot less fear if you're prepared and educated on what's actually going on here from the negotiation of the initial contract for what it says and keeping an eye on your rights and whether they're being breached and that you are responsible in doing the thing that you signed up to do. You did sign up to do it. And again, I'm not talking in this call about discharge and set offs. Those are all, um, it's a different topic. And in this situation, it's only a tiny bit. That topic covers all kinds of things, not just real property or foreclosure. Which is what we're discussing tonight. So I'm not going to cover that a lot here, but we do have other courses that discuss exactly those things. Okay. Position and structure changes the outcome. If you got solid protection of your equity, and you understand how you can and should use that equity to avoid the foreclosure, right? When they're coming, they're saying that you know, basically they're bad mouthing you. You don't pay your bills, right? And it's to them it's not personal. They expect it. They lend. It was kind of the predatory lending model, but they lend knowing that a strong majority of their borrowers are going to go and default somewhere along the line. It may not be today, it may not be tomorrow, but in 20 years, do you have a clue what you're going to be doing in 20 years if you're going to be able to continue to fulfill that promise, or are they going to come in and walk away with the equity that you built over 20 years, when you could have taken care of that up front? So, what does the course cover? In the full course, trust structuring, administrative processes, notice frameworks on dealing specifically with foreclosure, how to come about this, come against foreclosure in an equity position. Okay, um, it's not just that, but the way that the courses go. There is case simulation of a successful outcomes and failures. So you'll see what principles, what actions cause the difference between those two in each level of this class, or excuse me, in each class in that course. Okay. I've been at this a long time, guys. Um, 38 years, almost 39 years that I've been looking for freedom and studying law. Um, and I mean the whole of law, everything I could find. Okay. Long before there were computers and this easy access to information. But the reason I came up with all this, one is to get it all out of my head. I'm sick of thinking on it. and but there's nothing out there. There's nobody that says, here, this is step one, this is step two, and if you follow it along, you'll get the outcome that you're looking for. Now, and again, uh, prevention is much better than having to fight. Okay, and a lot less expensive. So learning this, if you're going into buying a house or structuring your trust estate, and want to know that you've got tools on how to protect what you're building there. Most folks don't go and invest in all kinds of properties, but they, that one big purchase in their lifetime is usually that real property. And it's horrible that when uh, you know 10, 20, 30 years in and you had to refi, or they talk you into some reverse mortgage thing. There's a lot of reasons why they do this. It's not because they expect you to pay. They expect you not to. They expect there to be breaches. Okay, so it has a lot more to do with your administration. It has a lot more to do with your record keeping and evidence, um, that you've kept throughout, than it is the payments that you miss. Okay, you miss opportunities to beat them. 20 years. These guys can't come up with a lot of the times an accounting or the original note and the securitized mortgage connected, which literally means they have no claim, and it happens a lot. Why? Because they sell them, they assign them, they anyway. You get the point. So um, we look at real world execution models in the course. Um, you would also obviously have access to, if we buy this course or any of the other courses that we offer, you get access to an AI bot we've been training now for about 2 years, a little over 2 years now, I believe. Yeah, it's pretty good if you know what to ask and how to ask, but it's a solid tool that comes with any of the courses, all of the courses that we offer. Okay, where you can actually test it against real legal procedures in whatever jurisdiction you find yourself in. So that's part of the benefit of these courses as well. Comes as an added benefit. So, who's the course for? It's for homeowners facing foreclosure, trustees managing assets, especially if some of them are real assets, individuals who are just seeking to control or expand their education in the financial realm, and anyone who really is ready to learn how that whole system works. Money creation into the economy, wherever you find yourself, is uh, in large part through the mortgage process. Fractional reserve banking, when they look at that, in their own documents, it will let you know how all that actually works. But this ties you into this mortgage that you got, and how did you get into, and how did your mortgage get over into China's stock market and in a bundled portfolio managed by some hedge funds. if you understand the inner workings and how it works, you can position yourself properly. So if you're just looking to learn how it works, um, the course is for you. Okay. Passive learners, if you're gonna, I would say save your money. Um, there's lots of gurus out there that will, sell you the remedy du jour. Um, but this isn't for passive learners. This isn't for somebody looking for a magic pill. The course is full of templates and step-by-step instruction. Okay, but you have to do the work. You have to, and again, there's work. There's active um, homework. All right, projects and assignments that you do that you build upon the class before. Okay. Um, if you're looking for a shortcut, if you need to, over the years, I can't tell you how many times I've got a call on Friday or Thursday, and somebody goes, I got to go to court for my foreclosure hearing on Monday, and I don't know what to do. And I don't have a lawyer, and I haven't done anything. I got these notices, and this is when the court case is. What do I do? And do you have a magic document for this? No, it doesn't exist, guys. If you want to have a remedy when and if a situation comes up, learn about it ahead of time. The time when when you can do it and look at it and contemplate the principles and concepts and actively engage yourself in the processes when there's nothing at risk. So if you're looking for shortcuts, guys, this is not it. I'm not selling guru shortcuts for the day. Okay. This is a structured course. It is, I would say, a master level course. Okay. In learning about foreclosures and not just foreclosures, but what leads up to them, what happens the second those contracts are signed, where those notes go, all these types of things are in the course. Okay. And if you're just looking to discharge your mortgage debt, um, because, the secret account that you're chasing or something like that, um, I'm sure there's folks on this call that are current students, um, and we talk about real stuff, accounting. That's a real thing, okay? Especially when you're talking about foreclosure, okay? But we deal in accountings quite a bit, okay? And that's where it starts. It starts in the administrative process on the private side, not in the courtroom. And if you can learn how to deal with it before it ever gets to a courtroom, you may be able to build a stronger position out of it and continue to retain the property. Okay. Again, foreclosure is not just about money. I said that earlier a few times. I've spoke around this. They don't care about the money. They'd rather have the windfall control of the property. If you are a trustee and you're managing a property, okay, it's not just the money for the property, right, that you're getting. It's control of the benefits, control of the legal title, and have that authority. Okay. Uh, I would say that if you're getting deeds of trust and mortgages, and these things are, theirs, the lender created, you are in contracts that you agreed to. Okay. And just because it's in your name doesn't mean it has to stay that way. You can move these things into trust, but it's got to be done properly so that is not to accelerate the note and have them call the note on you. So foreclosure is not just about the money. It's controlling the asset. It's controlling the position, the equitable position, the lien holder position. We talk a lot more about that in the course. A couple more guys, and we'll open it up to some questions. All right. You are not the problem. Your position is. If it's you fighting the bank and the lending institution and their lawyer and their trustee and their servicer and you know all of these different things, it doesn't need to be you against them. That's an emotional roller coaster and nightmare as trustee. Okay, you learn how to structure your defense, strategize ahead of time. Your defense is built in if you create and structure it properly up front. And that's really what I'm talking about. You reorganize that asset in a way that protects you, that it protects the equity in the property, gives you control without the liability. And that's not liability. I'm not saying a liability for payment, although, you know, if the trust can do the purchase itself, better off. You should be operating from there anyway. Nothing in the public should be done, you know, naked by just you. Should be protected with, within your estate. If you're going to the grocery store just to buy, dinner for tonight, that's your mitigated interaction. And again, it's structuring it so that later there is no fight, right? You understand the process, you understand your responsibility or the trust's responsibility. You have a structure, you have bookkeeping, you've got record keeping, okay? And you execute your plan. So you get the foreclosure course, the entire framework, okay? Trust-based positioning strategies. This is where these courses will always be from a private trust position, okay? Behind a private trust position, position of authority and subject matter jurisdiction, okay? You'll learn administrative process systems, how to deal with these lenders, case study breakdowns, wins and losses, what would cause a win, what causes losses, how to deal with it in equity, right? Step by step, execution models, defense strategies. All right, lifetime access to the course materials. Once you're a student, there will be study groups, live study groups that can be utilized among other benefits from within these courses. Okay. This course, okay, is 2,500, but I'm offering. I didn't get the coupon code in, but I'm working on redoing the website, and it's been up and down and stable, but it's I'm literally changing things as the site's live, so might see some dust and construction signs, but the access is there, and all the materials are there, and the tools are there. Most of the tools are there. The only one that and it should be there shortly is the interactive study groups that you can utilize within the course structure to live study with other students in the courses. Okay, but enroll by the 15th. You can say that you were on this call, and this 500 off is good until May 15th. If you uh, shoot me an email or a text within this group, I'll private message you a coupon code for the $500 off for this course. So you can continue reacting to foreclosure or step into a position of control and authority by taking subject matter jurisdiction over the property itself and the equity, especially within that property, that equitable interest. All right, guys, I'm going to open it up to questions. Give me 1 second here. I'm going to get back. I hope this all came through clear. I appreciate you guys keeping it down and letting me ramble on here with the presentation. Any questions, guys? I'll open that up to you now.
Yeah,
Hi,
David.
David.
Oh, hi, Valerie.
Hi. I have a question. Is there any way to go retroactively to try to do something about a foreclosure that's already happened?
There, there are things that you can do, especially if you had equity in the property prior to the sale, right? Um, you may have lost it. Now, equity, again, there's no statute of limitations if there were, if you had to, if we're going to go deep, okay, the bank committed some sort of fraud or predatory lending where there was some hanky panky going on, and the foreclosure was, you know, um, violated rights. You could go back in and possibly, you know, reopen that case and go about it under a different, and you can sue to have, possession back. Usually there is even after a foreclosure sale, there is usually a redemption period. Um, and usually, I mean, that's usually they'll offer that prior to sale. I've seen it go after sale. This is why again, I've seen a lot of folks stop a foreclosure in its tracks by doing administrative process, and it looks like there was a win, right? They stepped back. They didn't keep coming. They paused in the case. Okay, they went silent, and a lot of times they'll do that to reposition and then assign a new service company, or maybe sell the note because they know that it's going to be non-performing, right? And they'll start the process over again with the same trustee or same name, similar uh, to the rights that they were pushing in that first attempt. And they'll wait till the statute's almost up on a contracted debt. So there's statutes of limitations on collecting debt. Most states 3 years, maybe up to seven on on certain types of contracts. So yes, you can go back in if you find discrepancies in how the case was. Now you've got new eyes, and you understand what was going on, and or you didn't have representation and they made it, or they misrepresented you. There could be all kinds of defects with cases, and it happens more often than not. So yes, you can go after it. There's even I've been working with someone on a trust that's over 30 years old, and close to that from when the one of the two original grantors died, and it became a irrevocable trust. And the surviving spouse acted like there were no other trustees. There were four other trustees who became co-trustees after the execution of the will, and properties were sold without knowledge or approval from all of the trustees, which was very explicit in the trust indenture. And those properties were moved out of the trust. So if they were sold without the proper authority, case can be made against them, and accounting for all proceeds, and can even be um, re, um, what is that? Reconciled back into the estate through the court order to void the original sale, and then anything up the chain. So yes, it can be done.
It's really interesting. In this case, it's over 10 years since the property was forced into foreclosure. I had bought it with um, three other people, and two of the three would not rent the property. They would not make payments on the property, and the only thing that they wanted was it to go into foreclosure. They said, nope, it's going into foreclosure. And it was during the time when property values were really escalating, and it could have sold for more than what we even bought it for, definitely more than what we owed. And I went through a lawyer and gave, like, it was all documented that I requested it be sold. I requested, it to be at least rented to pay the cost. And these other parties said, nope, we're not going to. They refused. I got it all documented. And then eventually it was sold for more than what we even paid for it. And all of the equity, to my knowledge, all of the equity that I put in was lost.
Yeah, that sounds like a very unstable partnership. And in that case, I mean, you know, heck, I'm in a probate situation, and for my mom's house in Florida, there's three interested parties, including myself. Um, Two of us are in agreement. The other is in possession and sole possession, and 2.5 years, and it's taking to continue to fight to eventually force a sale. And 2 years ago, the property was probably worth about $70,000 or $80,000 more than it is today. So missed opportunities, you know, your other partners. I mean, you could track it down. I'm sure there's a record keeping. There's got to be a record of the sale, the proceeds, where they went, who got them. Um, but I mean, in a situation like that, I mean, I would go back in myself and look at the parties. Where's the contract? How was that expressed was there a mortgage on the property? Obviously, unless it was taken for taxes. But if they say that they're not going to pay, well, I'm getting some feedback. Um, if um, they refused to pay, or they didn't want to rent it, if they had possession, as an interested party, you'd have rights to force those things, or even force a sale. Them, it's called waste. Okay. And it's inequitable. If two interested parties ganged up on one and said, we're just going to let it go into foreclosure, and there's nothing you can do about it, your interest doesn't matter. That is inequitable. Okay. That can be challenged as waste, and it can show that they don't have clean hands, and that you come again. If you're coming in equity, you come with a solution. In that case, you could have maybe bought them out rather than them getting nothing. Let them hey, if you're giving up, then just convey all your rights and interests to me. I'll fight it myself. So there's lots of ways to deal with things if you're thinking as a trustee with that mindset. Um, it's tough when you get into a situation like that. And yes, after 10 years, you could probably track down, do a title search on the property, all the hands it's passed on from the time that it was an interest of yours, and I'm sure you could track down that information. It may not be easy, but if you were on the account, you shouldn't have a hard time getting it.
I have a lot of the information. Yeah. Yeah, I can get that.
Yeah. And again, I mean, if it's just tracking down what was owed, I mean, the equity is easy to figure out at the time. I'm sure you can check a lot of, heck, you can even see the sale, what they sold it for at that time, right? And what was owed, you'll know the difference between what it was sold. Now, that may not be an exact equity, because, you know, most of the time when they do a foreclosure sale, it's way discounted to, we'll sell it to you for what's owed to us. And if you have a lien on the equity, right, They can't do that. You have a valid, perfected claim on the balance above between the market and what's owed to them. So good question, Valerie. And yeah, you could track it down whether there's anything there to find as far as where the equity went and chase it. I don't know what the numbers are, so I couldn't tell you whether or not it's worth the gas to get there. But is it possible? Sure, absolutely. If there was something that was taken that belonged to you, equity says there is no statute.
That's so.
What was that?
My dog's barking, but thank you very much. I'll be working on that. Great.
You're welcome. Any other questions? I saw somebody earlier jumped in.
I'll shoot.
Okay.
Is there a basic or common reason why folks that convey a property into their trust, most of the time, well, at least for me, I notice that they're usually not successful if they have to go through any type of foreclosure proceeding. Is there a primary reason why securing it inside a trust isn't working?
Well, it all depends. Again, I mean, there's okay, so talking about it being in a trust. Like I said, there's certain requirements, and boy, for the life of me, can't remember the name of the. I could track it down, maybe put it into the chat in here, but there's rules, okay, about acceleration and trust. So when you go and you just blanket put your thing into a trust and convey all rights, titles, and interests to that trust, I'm trying to make it simple to answer. Um, it's considered a sale. The original borrower doesn't retain an interest in the property that they're paying for, and they find that as a total conveyance. And um, whether you're putting just your equity in it or whatever you're doing doesn't make a difference at that point. If you don't retain a certain percentage of beneficial interest in the property, and this is where a land trust or a, I'll call it a land or a real estate trust can be created and protect that equity, where even in a purchase. So let's say we don't want to go to the bank, right? And I want to do we create a trust where I am gaining interest shares, okay, interest in the beneficial interest, 90%. Sellers retaining 10%. Their financing stays in place, and the trust pays the mortgage and the taxes and the insurance until it either sells it or pays it off entirely, or pays the note off or refinances it. So there's lots of ways, but that trust stays intact, and a trust that's properly structured like that will not cause an acceleration into foreclosure. So that's with the upfront structuring. So if that's not proper and it doesn't fall within those parameters, the court can flip that outside the trust and say that it is a sale, and it caused an accelerated payoff of the loan or a call on the loan. So that's how it would have to be set up, not to trigger a foreclosure event where they're saying the property changed hands and the buyer wasn't a party to the mortgage, basically. Does that answer your question? As
I
far
follow
as
you.
okay, because I mean, that's an important part of it. If you look at how the trust was structured, it'll tell you why it failed in a foreclosure defense. So somebody, and I've seen people get into financial trouble, right? And right before, um, 30 days before the record of their default shows up on the lender's books, they just stick the thing into a trust, blanket into a trust, quit claim their rights, titles, interests. However, that does cause an acceleration. So a lot of these fly-by-night trusts that you see out here, put your trust in, put your foreclosed property or the one facing foreclosure into a trust. Every court is going to turn around and collapse that trust and take
Mm-hmm.
jurisdiction over it, especially if the finance documents are governed by whatever jurisdiction the property's sitting in. So,
Mm-hmm.
yeah, if if it's not properly structured ahead of time, a last minute fix, it's not a last minute fix. And a lot of times people think, oh well, if I put it in a trust, nobody can touch it. Um, yeah, that won't go over very far if it was, 60 days into a 90-day default on payments, right? 60 days in, you go and set up a trust for the property. Okay. But the court would look at that as after the fact. You're already
Right.
in trouble. So that's why it's easy for them to uh, logically reason that it should be collapsed. It was used as a fraud or to hide assets that are not
Mm-hmm.
necessarily theirs. So that's why a lot of them fail. It's more about pre foreclosure positioning. Like when you buy the property, you're already protecting against that. You're
Right.
protecting your equity. You're protecting your position. It wasn't an afterthought when you get in trouble. And that's why a lot of those trust situations that I hear about, where the trust gets collapsed and the trust situation didn't, the trust itself, the entity that they created, did not help in their foreclosure action. There's a lot more to it than just a piece of paper. It's action. It's deeds is what you're dealing with in trust, right? And minutes of those deeds, those actions that you are administrating and doing within your administration, and how you operate and manage your affairs and how you document it all. So when you get all of that, you know, focused into one system, it's a lot easier than shooting from the hip and hoping that you can find last month's mortgage receipt and the tax bill that you can't remember where you laid it, and you know what I mean. It's hard enough, and you think about it. These foreclosures are going in every single court and every single county and all over the place all the time. These judges are seeing these cases and they shuffle them through so fast, and especially in a non-judicial state. It's literally going and getting the clerk's signature, and that's it. You have to be the one to sue in a non-judicial state. So there's a lot of things that come into it that you can't learn between Thursday night and Monday morning if you're fighting a case and you're in the middle of it. It's much, much better to pre-plan some strategies and have them in your pocket. Um, we don't just, in the course, it doesn't just talk about the pre-planning. There are complete sections on defense strategies. Okay, if you're in trouble, I want to put that out there now because it's not just. It's better to be able to do it ahead of time so that you're not in trouble. When you're not in trouble and you're not in the middle of a battle, that's not good learning time. That's stress. That's frustration. That's emotional, and it's frantic. It's definitely not structured and planned. So your best bet if you, are in real estate, whether it be your personal house or you're flipping houses or you're investing or whatever, ahead of time how to protect the equity and all that stuff. Otherwise, what are you building it for? You're either building an inheritance for you and for your children's children, your grandchildren, your grandchildren's children, or you're going to make some fat cat bankers a little bit more powerful and add a windfall to the mix, which is nothing new for them. It's pretty much pretty easy these days because there's so many people that just don't know how to protect their assets and it's not just homes, it's every asset that you can administrate over and protect, um, which is all part of a holistic system that you can utilize to protect assets, businesses, relationships, marriages, and children, and business relationships. These structures are designed to manage your affairs, not just a home or a car, or it's, I'd say that wily straw man slash legal person. I mean, it's a dead entity that's been hanging on your shoulders that you've animated for your life. Getting in a position where that's reined in and controlled, right? It's a slave regardless, but it is, it's just like another tool. But if it's wielded in a individual's hands, it's assumed and presumed that it's the individual themselves, not separate. So there's always that degree of it's on my back, right? That burden's on your back, and it is literally. And with this system, that's one of the first things we rein in. Everything else afterwards. So anyway, any other questions? I'll take a couple more questions if we've got them.
Hello, David.
Hey, Thaddeus, how are you?
Good, you.
Hmm.
Good. Can you touch more on the holder in due course and bona fide purchaser, and also the separation of the note from the charge?
Let's do them one at a time. Go ahead. First question was the holder in due course, and what was the second part of it?
Bona fide purchaser.
Bona fide purchaser. It's not necessarily a title. However, the holder in due course, okay, is the one who has the the mortgage note and the mortgage contract and the note attached, right? It's properly attached.
Mm-hmm.
Okay. The holder in due course has both sides of that contract and is entitled to they have usually the holder in due course is just like possession of the property, right? That's their security. That's their property. That's their house. That's what they're foreclosing for, is the rights and interests within those documents. So those two documents, if they're separate, which happens all the time, okay, if they're separate, they can't be the holder in due course. Therefore, they lose standing.
Correct. Now,
Okay.
how could he be a holder in due course when they didn't take it free and clear of any not encumbrances? I'm trying to think of the right word here right now.
Well, if they can securitize it and send it down the way, right? If they took the note and held the security, the mortgage, and sold the note, which is often what happens, that is separating the note. They sold their right.
Yeah.
Right? They lost their standing because they've already been compensated. Now, the purchaser may have inherited those rights, right? Whoever bought that note may have inherited some of those rights. And then the proper party to foreclose, they would have to have not only the note, but the actual mortgage, the security behind it as well. That doesn't change that position. To be holder in due course and bring a legitimate claim, they're going to need to have both of those.
Correct. And more often than not, the bank, when they assigned and sold their receivable, it wasn't, depending on the true sale of that receivable, whether it was, secured financing or a full assignment, they're just acting as a servicing agent on behalf of the trustee to collect on an account that's not being serviced anymore.
Correct. Yep.
So,
And it happens all the time. And, even after a foreclosure or if it falls apart and you were successful, I know quite a few people that have fought off these foreclosure actions for years, even went to jail, removed from the home, and then went back after they got released and the locks were changed and went right back in and regained possession. And nobody bothered them for 2.5, almost 3 years till the statute almost ran again. And here comes a new servicer and a new trustee and a new law firm. So, yeah, it happens. It happens all the time. It's a shady business, commerce, banking.
okay, just to touch on that more, could not at that time you seek an injunction against to not have that keep happening before the statute of limitations runs out?
Well, yeah, I mean, no doubt about it. I mean, you can definitely always improve your position, before, during, and after a round like that. So, yeah, I mean, and again, what we teach in that course is proper structure to be able to protect, defend, and document those rights. So, getting that structure in place between now and when they come back would help a lot. And again, you can bring your claim. I know um, somebody went where their property was discharged in bankruptcy. No holds, no claims from the lender at all. And it was discharged completely. And that didn't stop them for the last 9 years. Every few years, they just keep coming back and redoing it. And they go, oh, no, it's not against you, sir. It's the property. And because there were some missed opportunities to protect that and do exactly that, not just get an injunction, but to pretty much pre-void out a potential foreclosure by the rights being closed by the court. Right? It was already done, but was never administrated out completely. Notices weren't sent, follow-ups weren't done. So, yes, you can always improve your position, and there's always ways to structure and get it in order so that if they do come back, you have a much better chance this next time of having the case thrown out.
Okay, so in equity, then, as a bona fide purchaser, because of the unconscious ability of the contract and the lack, of consideration, we're with how does the bona fide purchaser fit into this?
Yeah, I mean, I don't talk a whole lot about bona fide purchasers. Um, how would you define that bona fide purchaser?
Well, my comprehension at this time is kind of like a holder in due course. They didn't take it free and clear of any, I want to say the word encumbrances, right?
Sure.
That's not the right word. That
Well,
as
there are there are encumbrances, there are terms, there's agreements, right? From the time that the septic and everything went on the grid and all these different things. So there's lots of encumbrances. We'll use that word,
okay.
right? But again, those are contracts, and if you bought the property with all those attached without dealing at them prior to closing, you're looked at as voluntarily accepting those things as good. And if you don't do anything about those encumbrances or covenants, we'll call them because that's really what they're called, right? No covenants you'll hear on people selling property, right? No HOA, no other, covenants. And usually you'll see that where it's bare land, the house hasn't gone up. So there hasn't, no need for the state to get involved with an assay and a secure, septic, and all these other, fee-based, things to get into, you know, uh, get your building permits and all these other things they require, right? And everyone comes with their own covenants. And those covenants attached to the titles. And again, when you're in trust, you learn that, moving those public titles out and showing and, how that is done, that documentation and how they're conveyed and moved and created and recreated. Um, Documenting all that stuff effectively creates your evidence trail, right? Your chain of titles. And if there's administration that was done because of covenants that were prior to your acquiring it, you can trace down every one of those as attached to another party with some sort of interest in that title. And you could administrate them away if you want or can, depending on how those covenants are ascribed to that specific document, that specific top title or property. So yes, kind of again, you can track all that stuff down.
Yes. So
Good questions. Go ahead. You there? So it's called, there you are.
yeah, I'm here. Yeah. So for a house that's been foreclosed on and the sale's been made, tax sale or auction, whatever, the one that purchased it for the individual to go back onto that or into that foreclosure, the one that purchased it would not be considered a bona fide purchaser then.
No, there's still the matter of equitable ownership. And again, you can't do that after the fact. And you can, I mean, but you have to have seriously good documentation of every dime, um, good record keeping, even if you didn't set up and perfect your lien against the equity. Okay. You'd have to have really good record keeping to show payments made and literally put together the equitable bill for what's into it and present it as a creditor in the case. Okay. But if you were, and again, that's prior to a sale. And again, that's another type of action that can be taken to affect you not getting fleeced of your equity. But after the sale, the new purchaser, the purchaser that bought that, still, could end up and most likely would end up having to try and get you evicted as a tenant, um, or thrown out as a squatter. I've seen it happen quite a few different claims, but all in all, they take their foreclosure sale evidence, and they'll do a quiet title action and then a simple eviction. And by that time, most people have already moved out. Oh, I'm going to lose the property in foreclosure, and they move out. They don't stay. They don't keep possession, which is a mistake. And lots of people will leave, meanwhile, a foreclosure sale may not be 6 months, 8 months, a year, 18 months down the road. They just stop paying and walk out. They leave.
Mm-hmm.
And it happens often. This is why understanding this stuff up front and setting yourself up front to protect your equity, to mitigate and negotiate and or rescind any covenants that come along with that title. That's all, all that can be done. When there's time to do it and a process and a plan, right? Your intention. But after the fact, after the missed notices and missed opportunities to, come to some sort of an agreement to keep the property in your control, if it goes to that point, they'll see expenses and a big upside because they don't see any liens on the equity in that property. Believe me, the lawyers that work there, it's a no-brainer. It's a no-brainer, and you can go right down the line. And I would say the majority, forget majority, it's probably a very tiny percentage folks that protect that equity and the purchase within their own, within the private trust. Very few people protect their equity, period, in the property. So you can look at the records and say, if there's no lien, no, ongoing evidence of a lien against the equity in that property, and it's ongoing and consistent, they're going to turn around and well, it might cost us a couple grand to fight this, being that we created the mortgage out of nothing. The funding out of nothing, that we've had the opportunity to benefit in fractional reserve banking system and and have profited that way. We've profited off of the derivatives when breaches happened and occurred, and now we're going to just sell it for the balance remaining, and we'll get a windfall on the equity. Because most of these courts are not going to turn around and fight the equity position or claim the equity position on behalf of you or your trust, depending on who's holding the rights. But yeah, I mean, they're not going to really do that most of the time. It's just going to go, they'll have the sale and the bank will foreclose and they'll take whatever the windfall is. Doesn't mean you're not entitled to it. Doesn't mean you can't go back after it.
Mm-hmm.
But it's a lot harder after the fact than it would be to, plan for it up ahead. Anyway, any other questions? I'll take one or two more and then I'm going to wrap this up and I will post the recording here in this group and on the website as well. Any other questions?
One more, if no one else has one.
Go ahead.
Okay. With the when they separating the note from the charge. So when the accounting is, if and when the full accounting is provided, it'll show, number one, that they're acting as a servicing agent. They don't have the right to enforce, the bank does, and also that the note has been separated. So at that time, wouldn't equity step in and say that no, you can't, the bank can't proceed anymore in this foreclosure because they don't have the legal standing, they don't hold the title.
And again, it's up to you to press the issue. And in that case, evidentiary hearings, motions for discovery, these are all tools that can be used, again, if you know what you're looking for. So, yeah, I mean, what are the evidences of their standing? Objection. No evidence on the record that shows that that the plaintiff has any standing. There's no accounting. There is no holder in due course. There's nothing on the record. I move for discovery and an evidentiary hearing. I mean, these are just simple things, and understanding how it works and the tools that you can use even in a courtroom situation like that, right? That you'll get a lot more accomplished. It's these little things that like that simple, really that simple. No accounting, no note and mortgage attachment. There's separation there. These are little things that are big things because when there's securitization and sales and monetization and all these different things that go on behind the scenes, yeah, title split. Well, I sold the note to the Fed so we can create this and then pay that and do this and then lend that. And you see how the accounting could go, chaotic very quickly.
Mm-hmm. Very much
Drawing,
so.
Have them go and let's see how good their records are. Right, and that's how you would take hold of that situation. They're claiming, I can't object to something I haven't seen, right? But I can object that it's not there. And if they have a valid claim, shouldn't I be able to see where they're the holder in due course of a claim with rights of foreclosure? I mean, come on. And most folks never even think about it, and most lawyers won't do that. Most lawyers are not going to do that. They're not going to do a declaratory action to have the rights spelled out between who has, it's not a one-sided rights. It's all the parties. Who has rights and what are their responsibilities? And using a declaratory action to get answers and to hold them at bay and to define the equitable situation. Who has rights? What are they? And what are the responsibilities? And what would be remedy for breach? I mean, it's supposed to be a meeting of the minds when you go to court, and that's how settlement comes in, right? But you don't need the court to come to a meeting of the minds and get past the situation and move back both parties back into equity.
Mm-hmm.
It's just a little bit better understanding of what's actually going on. And, most people don't know that they can contact them and negotiate better things. There's full-blown companies out there making a fortune on negotiating people's debts down. Which all it takes is a simple phone call and a couple of nice letters. You could do it yourself. So there's a lot of things that folks don't know, and that's what hurts them in the long run. And that's why, I put these courses together because I can help, but I'd rather not just, it takes up all my time to help one person where I can put it all down and put something out there that in all my time doing this, I've never seen courses offered that just say, okay, you're dealing with this. This is how you would deal with it. Oh, and it's flexible because it's, when you're talking about protecting or defending, you're talking a lot of times about either an administrator or a legal process, right? Or an equitable solution. And these things, there is no one size fits all for every situation. It's got to be flexible. It's got to be able to adjust for specific situations. And when we talk about, defending your trust estate or property within trusts, like real property. We spent a lot of time talking about how to defend and how to protect, dealing in those venues where you're going to have a judge and lawyers and witnesses and testimony and evidence and rules of procedures and rules of evidence and all that, and still be able to walk in there with some sort of understanding and solid direction as to how everything works. So, like I said earlier, I'm not selling, the remedy du jour. This is for people who want to study, who want the education and a system that you can, run by, or record keeping, for evidence, procurement, or use as a tool. Good record keeping. Pass an inheritance on to your children, your grandchildren, instead of the state. They take a lot as it is. When we deal with trusts, we're mitigating all of that to a minimum interactions. Dealing with the bank is a big interaction, right? It's a big interface. It's a place where, you're touching the public in a big way. And banks are highly regulated by the state. Heck, I think most of I'm not 100% sure about Canada, but I've been in other places, and those are state-owned banks. All of them are tied to the state, right? So they're going to protect their money window. All these mortgages are connected to fractional reserve banking and how money enters or currency enters into the system. New money is created. We discuss all of that in this course. Anyway, guys, any last question that somebody just has to ask before we wrap it up?
Hi, Dave.
Hello.
Yeah, it's Chris here.
I'm looking down my screen trying to see who's talking. Go ahead, Chris.
How you going? This is it goes back to the first question that was asked by that lady retroactively.
Okay.
Foreclosure 4 years ago. But from what I've learned over the last few years, reclaiming securities and so on. So, what's your view on at the onset of a mortgage with the promissory note that a claim can be brought once status has changed, and you become secured creditor, that you can then secure all past securities, claim all past securities, and bring a claim of fraud, breach of trust, unjust
If there
enrichment.
is fraud or fraud in the inducement, I mean, most of the time when you buy a house, well, I'd say all the time, anybody who's bought a house has their deed or title to the home, and they look at it, it says you are a tenant. Did you really buy it? Or is it still in a trust in the public? The state has an interest. Remember back in the early tiles of the presentation, the state, the bank, you, and hopefully your trust. And the trust is a secured party, especially when you're filing your UCC liens or, the equivalent in another country, to protect your equity interest and perfect your claim on that equity. Right? So you've got to, and there's a lot more. I know where you're going with the security interests and things like that. It's not just a blanket statement. You're dealing with a house and one security. Okay? If they were sold, if there are, and again, we know they are, other securities were created. We know this all happens behind the scenes with the fractional reserve banking. that other securities are created on that note and security agreement. Monetization occurs, right? Fractionalization occurs. That is an accounting. And again, I agree with you. We've talked about a lot of things on this call in statutory foreclosures and some equitable principles. I didn't get into when I said that anybody with an interest can foreclose. So if you have questions like that, is there, where's the real accounting, the full accounting? You're not looking just for your statement, your monthly statement. There's a lot of things that go on in that account. If there was a breach, there's a derivative or an insurance payout at 60 days, 90 days, 180 days, right? That covers the lender for that breach. But it doesn't cover you, and they'll double dip. And it happens all the time. And those transactions, could they be, could they be committing fraud by double dipping? Sure could. Does anybody call them on it? No, because nobody sees that second accounting, right? They're going to guard it with their life. So utilizing your equitable position for equitable foreclosure to force discovery, among other things, this is all discussed in the course, for sure. Equitable foreclosure and turning the tables and things like that. And for this call, it's quite advanced, but it's an advanced course. So those things that are within the course that we talk about is equitable foreclosure, using equity to foreclose and get a true full accounting for the account, not just for your servicing account, right? Where they keep your payments every month and keep track of that. So that's your statement account. But where's all the money that was created? The other 90%. 10's probably sitting in another account as their required security to keep on the books, and the other 8, who knows? Where did it go? It was created and put out there in your name or in the name of whoever signed that note and security agreement. Wasn't authorized by the agreement. So there's lots of ways that you could look at a foreclosure and the initial transaction and reverse engineer a breach of some sort, a trespass of some sort, or some other sort of inequity going on behind the scenes. So, yeah, you're absolutely right.
And of course, there's no statute of limitations. You can go back.
Not on fraud and not where you've been equitably wronged. And it's how would you know until you find out, right? How would you know that you've been wronged, or how badly you've been wronged without that evidence, the full accounting?
Full accounting, yep.
Right? It's like the elusive, hidden trust accounts within the system, right? Where's the accounting? The accounting tells you to what extent and where. So it's the same with them, and that's why it rarely shows up in the courtroom on a foreclosure unless you really push it. The judge is not going to require it. They're not even going to require the accounting. They're not going to require to see a holder in due course. They're not going to require anything. They're not going to give legal advice to you either.
Yep.
So you need to know what to do and how to do it ahead of time. It's a real tough fight. This isn't a speeding ticket. It's a tough fight, and the stakes are high. The more you know, the better prepared you're going to be, and the more the more options you create. With the sooner you start protecting it ahead of time. I mean, going into it, if you know that going into a property, it's going to serve this purpose, and this is how the titles will be controlled, and the equity will be protected. And you go into it that way. And then if there is an emergency, it's not, the place isn't going into foreclosure for mismanagement and a breach on your part. Right? You've done everything you can to protect the asset. Some emergency happens, and things happen that are beyond the trust's control to pay, and you have equity. You can negotiate. You can offset. You can, forbear payments. There's so many different things you can do before you reach that point in the private, where it's just talking with those that can make make the deal. That's all it is. But once it gets to court and everything's going haywire, emotions take over, and it's me. I'm screwed. I screwed up the family, and then there's guilt and all kinds of things that people carry with them, and that's no way to fight. You're going into a fight. A courtroom battle is a fight.
Yep.
Yeah, and if you head somewhere else, you're going to get it knocked off. That's just how it works. They're there every day training to tell you and show you how you're going to get run over and like it. You need to know why they can't do that ahead of time and make sure they don't on your watch. That's all part of being a good trustee and protecting and defending the things that were entrusted to you. And this is an advanced course, establishing your trust estate, teaching you structure and how to set up your trust, administrating your trust from private or public to private, and then learning how to defend and protect it, at least at a foundational level, a strong foundational level, and then you grow out on that. So,
Yep, sounds good.
thank you for your questions, Chris.
Thank you, Dave. It's great.
Oh, my pleasure. All right, guys, I'm going to wrap it up. I will post the recording in this group. You'll also be able to find it on the bulletproofsolutions.org website. And again, if there's anybody who's on this call or hears it between now and May 15th and is interested in the course, there is a $500 discount. Would have to be done through a code. So reach out to me through Telegram in this group. You can find my name in there and shoot me a side note. Let me know you're interested. I'll get you a coupon for the $500 off on the course. And you could also go to the website. All the other seminars that I've done in this group are on the website there as well. All right, I'm going to stop the recording.